let me also talk about the role of media. A trial is essentially a process to be carried out by the courts. However, in the modern day context, trials by digital media are an undue interference in the process of justice dispensation, crossing that Lakshman Rekha many a times. This is especially all the more worrisome when those sections of people start scrutinizing the judicial process who possess only the half-truth, those for whom the concepts of judicial discipline, binding precedents, and inherent limitations of judicial discretion are elusive. This section of people, the half-truth knowledgeables, are a real challenge to the dispensation of justice through the rule of law. Social and digital media is nowadays primarily resorted to expressing personalized opinions more against the judges per se, rather than a constructive critical appraisal of their judgments. This is what is harming the judicial institution and lowering its dignity. The constitutional courts have always graciously accepted informed dissents and constructive criticisms, but their thresholds have always debarred the personalized agenda-driven attacks on the judges. This is where the digital and social media needs to be mandatorily regulated in the country to preserve the rule of law under our Constitution. Attacks attempted at judges for their judgments lead to a dangerous scenario wherein judges would have to pay greater attention to what the media thinks rather than what the law actually mandates. This puts the rule of law on the burner, ignoring the sanctity of respect for the courts. In the case of Sahara Private Limited versus SEBI, the Supreme Court devised the doctrine of postponement of publication. It is a precautionary measure where the media is not allowed to publish opinions about the sub judice matter till the hearings conclude. This doctrine of postponement is not to be read as a censorship or a prior restraint, but rather a safeguard against possible abuse. This can be one of the viable options, considering how the non-judicial factors are shaping the public opinion in this matter. A judicial verdict, right or wrong, is always by a court vested with powers under the Constitution of India as a court of record. The Supreme Court and the High Courts act as court of records by virtue of Articles 129 and 215 respectively of the Indian Constitution. The remedy of any judicial order or a judgment is clearly not available on digital or social media, but before the superior court of law in the judicial hierarchy. In India, which still cannot be classified as a completely mature and informed democracy, social digital media is employed frequently to politicize purely legal and constitutional issues. One of the cases in hand is the Ayodhya verdict, which was essentially a land and a title dispute bordering upon the title of a deity. However, by the time the final verdict came to be delivered, the issue attained political overtones. all those imputing intentions and motives to the Supreme Court for the Ayodhya verdict conveniently forgot that someday or the other, some judge had to decide the contentious civil dispute, which was indisputably one of the oldest litigations pending in the court of the country, running into more than 38,000 and odd pages. This is where the heart of any judicial proceedings before the constitutional court may disappear, and the judges deciding the dispute may get a bit shaken, which is antithetic to the rule of law. This is not healthy for the rule of law. Another issue which has always been a hot cake for the social and digital media is the punishments in cases of serious offenses. The immense power of these platforms is persistently resorted to for precipitating a perception of guilt or innocence of the accused even before the trial is over. This also sacrileges the rule, especially in high-profile matters where either the incident is hyped or the accused is a big man. Even before the trial is over, the society starts believing that the outcome of judicial proceedings ought to be nothing except conviction with the extreme penalty for the accused. Therefore, regulation of digital and social media, especially in the context of sensitive trials, which are sub judice, must be dwelled upon by the Parliament by introducing appropriate legislative and regulatory provisions in this regard.